morning, everyone, and thank you to Mid-Atlantic Christian University for inviting me to speak here today on a subject that I am extremely passionate about, the United States Constitution. I hope whether you were looking forward to hearing from me today or you were politely attending, that I convince you to be as passionate about this historic document of monumental import that impacts so many here and abroad. There are just under 200 nations in the world, and only 28 of them, according to the Economist Democracy Index, that have full democracies. About 54 more have some sort of democracy, and 85 are not democracies at all. In fact, more than 1/2 of the world's population lives in a democracy, but sadly, almost 40% of the world's population still lives under authoritarian rule. According to the Heritage Foundation, our Constitution is the world's oldest written design of government in operation today, and the first written instrument that both designed and limited national government. The Foundation published a lecture in 2013 that compared our Constitution to others in existence in the world, and there are many interesting facts unveiled in this study. While ours is the oldest Constitution, post-communist Hungary, by comparison, has an infant constitution, if you will. Their first effort following communism at writing a governing document as a democracy occurred in 1989, and I venture to say that is in many of our lifetimes. In the first 20 years after the adoption of our Constitution, there were but 12 amendments. But in the first 20 years of the young Constitution of Hungary, there were 49. Just 10 years ago, Hungary prepared a new constitution, and after only 1 month of debate in Parliament, it was adopted by 2/3 vote and called the Fundamental Laws of Hungary. 200 plus years after our Constitution was birthed, as the framework in which our citizens' rights are established, ours is still the law of the land. Hungary included our constitutional standards such as separation of powers, rule of law, and judicial review, but also, interestingly, expressly included marriage between one man and one woman and life beginning at conception. Now, not everyone admires our Constitution the way the framers and Hungary do. For example, one of our own Supreme Court Justices, Ruth Bader Ginsburg, said during her trip to Egypt in 2012 that if she was drafting a new constitution for a country, she would not look to the U.S. Constitution, explaining it was, and I quote, a rather old document. The comparative study of constitutions in the world found that the most popular shared rights included freedoms of religion and expression, the rights to private property and privacy, and guarantees of equality, which appear in 95% of the constitutions in existence. At the bottom of the list are the right to bear arms, which only appears in 2%, and the protection of the fetus, which only appears in 8% of the constitutions. Only 2 of 60 provisions, most common to all, have decreased in popularity. The right to bear arms, which is a part of our Bill of Rights, and the recognition of an official state religion. Now, why should you care about the Constitution of the United States? After all, many college students and others today oftentimes see themselves more as citizens of the world than American citizens. It is my most sincere hope that our conversation today determines for you that, second only to God's holy word, the principles of individual liberty outlined and preserved in our Constitution will affect every single opportunity and choice that you have in life. What is fundamentally and uniquely American is the foundation established by our Constitution that, aside from the consensus about governing in a democratic republican, where whomever wins the vote prevails in policy, either Republicans or Democrats, nonetheless, each of us individually has rights, whether we are in the majority or in the minority, that cannot be denied. Our government is limited by each of our rights. The government does not grant us rights. We grant to the government its authority. Yes. Specifically, our Constitution reads in the biggest type, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure, listen to these words please, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The wonderful thing about being asked to speak in this great land is that it allows me to share my opinions with you, and this is mine today. Unlike some, I believe the United States Constitution was, and remains today, the most brilliant design of government that has ever been authored. It fashions the most profound balance between the practical considerations for a framework of law to govern a collective group of people, while at the same time maintaining the establishment of fundamental individual liberties to each and every citizen. I know national pride is not politically correct these days with some, but I make no apology that this is my view, and I'm going to take the opportunity to advocate you share this view. And this is the aha moment for you students. This is the point you would write down, because this would absolutely be on the test. The single most significant point of the United States Constitution is not one of the rights enumerated in the Bill of Rights, but rather the accommodation of conscience. Think about this. The task before our fathers was to fashion a framework for governing a group of people from different backgrounds, different physical locations, different faiths, who were already governed to a degree by the individual framework of law established by each individual colony. These Americans chose to unite under the common cause of liberty to provide an overlaid framework that would provide for their common needs, like national defense. They had to fashion this framework while maximizing the consideration of each individual and their diversity, rather than their commonality. So, how is this possible? How do you impose laws for the whole and still respect the parts? In delivering the Constitution to the President of Congress, George Washington wrote this about that very task. It is obviously impracticable in the federal government of these United States to secure all rights of independent sovereignty to each, and yet provide for the interest and safety of all. Individuals entering into society must give up a share of liberty to preserve the rest. It is at all times difficult to draw with precision the lines between those rights which must be surrendered and those rights which may be preserved. And on the present occasion, this difficulty was increased by a difference among the several states as to their situation, extent, habits, and particular interest. In all our deliberations on this subject, Washington continues, we kept steadily in our view that which appears to us the greatest interest of every true American, the consolidation of our union, in which is involved our prosperity, felicity, safety, perhaps our national existence. This important consideration, seriously and deeply impressed on our minds, led each state in the convention to be less rigid on points of inferior magnitude than might have been otherwise expected. And thus, the Constitution which we now present is the result of a spirit of amity and of that mutual deference and concession which the peculiarity of our political situation rendered indispensable. That it will meet the full, entire approbation of every state is not, perhaps, to be expected. But each will doubtless consider that had her interest alone been consulted, the consequences might have been particularly disagreeable or injurious to others. That it is liable to as few exceptions as could reasonably have been expected, we hope and believe. That it may promote the lasting welfare of that country so dear to us and secure her freedom and happiness is our most ardent wish. And so concludes Washington's remark. This incredible task of balancing national, state, and individual interests and perspectives, the Founding Fathers provided for the one and only thing that could reconcile a framework of law that required individuals to cede liberty with the significance of providing for individual rights. That, my friends, the essence of brilliance, that which provided for the balance was the right of conscience, preserved to every single one of us. So, what is conscience? Well, it's certainly not something you can hold in your hand and point to for others to recognize. But conscience, you know it when you feel it. It is that nagging in your soul when you know you are acting contrary to what you believe is right. The right of conscience has an admirable and long history in our nation. George Washington, in writing his famous Hebrew letter to Rhode Island citizens, assuring them the new country preserved their religious freedom, wrote this: "The citizens of the United States of America have a right to applaud themselves for having given to mankind examples of an enlarged and liberal policy, a policy worthy of imitation. All possess alike liberty of conscience and immunities of citizenship. In fashioning the Bill of Rights, many of the proposed versions use the term right of conscience. James Madison introduced the first version of the First Amendment in the House of Representatives in 1789. And the version read as follows: "The civil rights of none shall be abridged on the account of religious belief, nor shall any national religion be established, nor shall the full and equal rights of conscience in any manner or in pretext be infringed." After debate, the second version read, "Congress shall make no law establishing religion, or to prevent the free exercise thereof, or to infringe the rights of conscience." Madison included the right of conscience in his proposed language for what became the Second Amendment. The right of the people to keep and bear arms shall not be infringed. A well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. This conscientious objector status is perhaps the most well-known example of establishing the right of conscience in our laws. How important was the right of conscience to the Founding Fathers? Thomas Jefferson had this to say about the priority and obligations of citizens to the laws of our nation. "A strict observation of the written laws is doubtless one of the high duties of a good citizen, but it is not the highest. The laws of necessity, of self-preservation, of saving our country when in danger, are of higher obligation. To lose our country by a scrupulous adherence to written law would be to lose the law itself, with life, liberty, property, and all those who are enjoying them with us, thus absurdly sacrificing the end to the means." The right of conscience is the critical balance between governing and the exercise of individual liberty. Means as citizens we must recognize some very important principles. Every citizen has the right to advocate that the laws governing each of us reflect our own principles, regardless of whether those principles are founded in faith or not. Faith principles in the context of the United States Constitution do not take a back seat nor priority over non-faith principles. People of faith are invited into the public square and may not be removed because of their beliefs, having equal stature with anyone whose views and advocacy have a different basis. Never allow someone to tell you you are obligated to silence because your views are based on faith. Never. Our laws will always reflect principles, and we of faith have the right to argue our principles should be that basis, as much as someone has the right to advocate our principles should not be the basis of law. But advocating for our own principles to prevail in law does not guarantee necessarily that they will. We are guaranteed advocacy, free speech, and expression of religion, or from religion, but not of outcome. Those of us who are offered this right of conscience to be equally invited into the governing process must recognize that those who do not share our views or our basis for those views have the same standing to participate. Therefore, as citizens, we cannot claim to know how fundamentally critical our freedom of liberty is under the Constitution and the value of that liberty unless at the same time we recognize others with whom we disagree. We are a nation that does not compel belief. It is the principle of our citizenship. It is common to our Christian faith. It is, in fact, the essence of faith itself, the voluntary nature of believing something, of personally deciding it is what we believe. We have a Pledge of Allegiance, and we invite citizens to recite it. But we do not compel the belief in the allegiance. It is the very, very foundation of each and every one of our individual liberties as Americans. So, how does all of this apply in the context of current events and each of our lives? You have all likely heard of the recent cases involving RFRA, the Religious Freedom Restoration Act, the one that was in the news in Indiana most recently, and Arkansas, and we also have a Senate bill and a House bill that are pending establishing religious freedom restoration in the state of North Carolina. The federal version, the Freedom of Information Act, was passed in 1993 at the initiative of then Representative Chuck Schumer, who is now the senior senator from New York, and the late Senator Ted Kennedy. And it passed unanimously in the House, and it passed the Senate too, with only 3 senators voting against it. It was signed into law by then President Bill Clinton. The legislation was a response to recent Supreme Court rulings that allowed government to impose requirements of persons over the objection of their religious faith. Prior to this law, the Supreme Court ruled that 2 Native Americans were justifiably fired and rightfully denied unemployment benefits because they tested positive for drugs in violation of state law after using peyote in religious ceremonies, which is a common tradition of their faith. It might surprise you to hear what Justice Scalia wrote for the majority, and I quote, "Laws, we said, are made for the government of actions, and while they cannot interfere with mere religious belief and opinions, they may interfere with practices. Can a man excuse his practices to the contrary because of his religious belief? To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect, to permit every citizen to become a law unto himself." Unquote. Well, people were outraged over this decision, and liberals and conservatives joined forces to pass the federal law that would protect religious freedom from the imposition of laws. The Supreme Court later ruled the new law only applied to the federal government, and so individual states began passing state versions of the federal law protecting religious freedom. The state laws met little resistance and were largely universally supported by liberals and conservatives alike, until the latest state, Indiana, passed theirs. These laws do not allow for a person to illegally discriminate because of religious beliefs. These laws require the government to show what is called a compelling state interest for a law to interfere with the practice of one's faith. If a state does not have a religious freedom law, the Peyote case establishes the right for the law to interfere with a religious practice without having to show a compelling state interest at all. It is intellectually dishonest for anyone to claim any of the religious freedom laws, federal or any of the state versions, allow discrimination against anyone. They do not. Religious freedom laws protect the right of a person of principle to assert a defense to compliance with a law that requires or prohibits action in contradiction to those faith principles. For example, a hospital employee, by her employer policy, was required to take a flu vaccine. As a principled vegan, she could not ethically agree to insert a vaccine made of egg product in her body. Now, she prevailed in her claim of religious objection, a religious freedom law. But no religious principle defense would ever trump the constitutional provision prohibiting discrimination. The state will always have a compelling state interest to prohibit discrimination. And I caution you today, strongly caution you, to be aware of intellectual dishonesty. For example, the use of false analogies. Let's say a florist had served a Chinese couple for many years. However, on one occasion, the Chinese couple requested flowers and volunteered that they were for a swingers event they were going to lawfully host. Morally and religiously opposed to indiscriminate sex with multiple partners, the florist refused the request. Now, the false analogy says, claiming that providing flowers to the event is participating in the orgy is like claiming selling fertilizer is participating in the bombing the fertilizer was used in. Now, why is this a false analogy? Did the florist have to know anything about the Chinese customers to object to participating in the orgy? No. She had to know about the orgy to object, but not have to know anything inherent about the customer. Did the fertilizer shop owner know about the event, therefore having the knowledge of the ultimate object? No. She had no knowledge what the fertilizer was going to be used for. The proper analogy would be the florist who learned from the buyer about the orgy use, and the fertilizer shop owner who learned from the buyer the intended use of the fertilizer. So I ask you, if the fertilizer shop owner learned from the buyer that the intended use, and with that the knowledge sold the fertilizer anyway, would the fertilizer shop owner be participating in the bombing? Intellectual dishonesty and false analogy is a deceptive way for people to make a point. And I think you can clearly see the difference here. I suggest that most people looking at a true analogy would say the fertilizer owner is participating in the bombing when selling with the knowledge of the intended use. Now, it is very likely that those who offer the false analogy, when corrected, would object to the true analogy, claiming there's a big difference between a bombing and an orgy. However, they didn't think the distinction was significant when they tried to use the false analogy to make their point in the first place. We see more and more and more legal decisions reflect opinion and emotion in this country rather than logic.
Here, here.
For example, in Oregon, a baker had a customer to whom she sold product previously. On another occasion, the baker would not agree to sell a different product to the same customer. The customer claimed to sell the second time was based on her protected classification of sexual orientation, and thus it was illegal discrimination. Now, if the customer, despite her sexual orientation, was served before, how can she now claim that the refusal of a particular product was because of her sexual orientation rather than objecting to the product? In fact, the baker will not agree to sell the requested product to any customer, ever, no matter what their sexual orientation. For example, if a person of the opposite sexual orientation, say the mother of the customer, requested the product, it would be refused to the mother as well. Unfortunately, the state of Washington concluded the baker was guilty of unlawful sexual orientation discrimination. That's it. In Colorado, a baker refused to sell a product to a man, stating she does not sell the product to anybody. The man complained the baker was refusing him the product because of his religion, and religion is a classification protected from discrimination by law there. But the state found this baker innocent of unlawful discrimination because it was a product she would sell to no one. In Washington, the customer was gay. In Oregon, the customer was Christian. In Washington, the product had a pro-gay message that the baker refused to everyone, no matter what their sexual orientation was. In Colorado, the product had an anti-gay marriage message that was refused to everyone, no matter what their religion was. In Washington, the product's message was inferred to the customer's sexual orientation status. In Colorado, the product's message was denied to the customer's religious status. So if a black couple was served by a vegan caterer a number of times, but when they asked the caterer to serve a banquet that celebrated hunting, she refused because of her vegan beliefs. Could the black couple, even though this caterer served them many times, claim they were being discriminated against because of race? Not if there were RFRA laws in place. We must demand, with any amount of courage and sacrifice required, an honest debate with regards to an evaluation of our liberties. This is a very difficult time for those of us of faith, who more and more feel like our principles of faith are no longer protected by law. Please, please know, this is simply not the case.
Here, here.
The law that trumps all others in this country, the United States Constitution, respects that faith principles may be equally advocated as the basis of law as any other basis. No matter how many times faith advocacy is characterized as hateful bigotry and the attempt to impose religious beliefs on others, the truth is, it is no more an imposition than the personal views of those who demand laws should reflect their non-faith principles. We are each responsible for these liberties. We are responsible for recognizing that our liberty is only secured by the right of all citizens to have equal liberty. The law that some are objecting to because it may protect someone other than them is the same law that tomorrow will protect them. You must choose to participate in government if you believe your liberty is valuable, rather than assume someone else is going to do it for you. You must agree to educate yourself about the rights so powerfully and geniusly preserved for you by our founding fathers and documents like our great Constitution, if you expect it to continue to protect those who are going to be following us as citizens. And perhaps most importantly, you must see a stewardship obligation in standing up to any erosion of these sacred rights for any other citizen. To any of you who feel a calling to public service, I invite you to contact me and I will share any insight I am able. For the rest of you, I invite you to hold my public service to account. Account to you and account to the Almighty. And finally, the cost of preserving freedom, your rights and liberties, is huge. Of those who pledged their lives, their fortunes, and their sacred honors as signers to the Declaration of Independence, 5 were captured as traitors and tortured before they died. 12 had their homes ransacked and burned. 2 lost their sons in the Revolutionary War. Another had 2 sons captured, and 9 died from wounds or from other hardships of the war. And so I ask each and every one of you gathered today to hear from a representative of your government, what price are you willing to pay? I leave you with these words from our first president, George Washington. The preservation of the sacred fire of liberty is finally staked on the experiment entrusted to the hands of the American people. God bless each and every one of you in these United States of America. Thank you.